final element of a negligence claim is defences. There are three primary defences: contributory negligence, illegality, and volenti. The Law Reform Contributory Negligence Act 1945 developed this partial defence. It allows the amount of damages awarded to be reduced in instances where the claimant was partly to blame for their own injuries. Under Jones, when considering if the claimant contributed to their injury, foreseeability criteria should be used. Was the type of injury foreseeable to the claimant? Lord Denning provided further guidance in Froom by saying that, in that case, the negligent driving was the prima facie cause of the injury, and so the defendant should have to pay most of the damage. He makes clear that this is not about blameworthiness, but about equity. The illegality defence means that people cannot sue for damages caused by their own criminal act, as seen in Gray, where a claimant was denied damages for killing another person as a result of PTSD caused by a train crash. This can be departed from on policy grounds though, as seen in Patel, where the claimant tried to sue for their money back after giving it to be used in insider trading. The court allowed this claim as they did not want the defendant to benefit from criminal activity. The final complete defence is volenti, where a person cannot sue if they have voluntarily assumed the risk. This requires them to have full knowledge of the circumstances and understand the risks of injury. Volenti also includes exclusion clauses which allow companies to exclude their liability by making the victim acknowledge that the activity is carried out at their own risk. This is subject to certain restrictions. Under the Unfair Contract Terms Act 1977, a company may not exclude liability for death or serious injury, and any exclusions must be fair. Under the Consumer Rights Act 2015, all consumer contracts must be fair, and where there are multiple readings of a contract, the one which is most favourable to the consumer will be used. There are two other important issues to consider when it comes to assigning liability: omissions and the liability of public authorities. The first is that negligence must arise from an act rather than an omission. There is an exception to this though. A defendant will be liable for the act of a third party if the third party is under the defendant's control, even though the defendant did not do anything. There are also special rules governing the liability of public bodies. In general, people are responsible for their own actions and public bodies cannot be liable for acts of third parties. However, there may be liability where the public body has assumed a specific duty of care towards a particular person, as was the case in Kent, but not in Michael.